The doctrine of collateral estoppel has its genesis in civil litigation and applies to criminal proceedings. People versus Goodman, 69, New York 2nd, 37, 1986. This principle is embodied in the Double Jeopardy Clause of the Fifth Amendment of the United States Constitution. Bash versus Swenson, 397 U.S. 436, 445. Collateral estoppel means simply that when an issue of ultimate fact has once been determined by a valid and final judgment, that issue cannot again be litigated between the same parties in any future lawsuit. Swenson, 397 U.S. at 443. Therefore, if the ultimate fact issue, i.e., that which is essential to conviction in the later trial, is resolved in defendant's favor, the subsequent prosecution is foreclosed. Goodman, 69, New York 2nd at 38. However, if the resolved issue concerns an evidentiary fact tending to establish guilt at the second trial, the subsequent prosecution is not precluded. Only further litigation of this evidentiary fact is prohibited. People versus Acevedo, 69 New York 2nd, 478, 1987. To invoke collateral estoppel, a defendant must establish that the prior proceeding resulted in a final judgment. Goodman, 69 New York 2nd at 38. Gold, 36 New York 2nd at 412. Mutuality of parties, Goodman, 69, New York 2nd at 65. People versus Saylor, 65, New York 2nd, 224, 229, 1985. As well as the incentive to litigate the issue in the first trial. People versus Fagan, 66, New York 2nd, 815, 1985. The defendant must also establish that the issue was necessarily decided in the first proceeding. Acevedo, 69, New York 2nd at 484, 485. Goodman, 69, New York 2nd at 40. Since defendant faces a formidable task in trying to establish that an issue has been resolved in his favor in an earlier proceeding, the collateral estoppel rule is not to be applied with a hyper-technical approach, but with realism and rationality. Acevedo at 69 New York 2nd at 487. Quoting with approval, People versus Goodman, 60 New York 2nd at 40. The defendant has established all the elements of collateral estoppel. It is noted that the District Attorney of Kings County represented in the habeas corpus proceeding the named defendants, Department of Correctional Services, and the Attorney General of the United States. Contrary to the prosecution's argument, the determination that the Maryland crime does not qualify as a New York predicate was an essential determination to the petition of habeas corpus. Without the determination, the defendant would have failed to establish both of the prongs of Strickland, and the petition would have been denied. Thus, ordinarily, the doctrine of collateral estoppel would apply in this case. However, this court must still determine whether the defendant is a second violent felon. In New York, neither the negligence of the people nor of the court authorizes the imposition of a first offender sentence on a predicate felon. People versus Scarborough, 66 New York 2nd, 673, 1985. Reviewing on dissenting opinion, 105, Appellate Division 2nd, 1107, 1108 to 1109, 1984. People versus May, 180, Appellate Division 2nd, 974, 975, 1992. See also Rosa versus Herbert, 277, F Supplement, 2nd, 342, 356, 2003. By law, the court is mandated to sentence a defendant in accordance with the penal law and cannot ignore mandatory sentencing provisions. Is okay.
So.
You're getting some good speed there, man. Not even know as fast as I can. It wasn't timed out, but it was a good take.
My software says 157 for
It's up there.